My lords, my lady, 2 points to pick up, if I may, that were left hanging before the short adjournment. One is in relation to the other reference to prospects in the SPA. It's, I'm told, not in the bundle, and it's a hair I should not have set running. But what it says at 10.5.3, it's in. This is in Schedule 5 to do with tax warranties, and it's to do with a reasonable prospect of success needing to be certified in the opinion of tax counsel. So it's very different. Nothing. It's not even prospects. It's prospect.
Yes.
That's what I get looking through the full contract in terms of prospect. The other point is, I believe I failed to answer my lord's question about looking at the reply in relation to the counterclaim, which I should make good, which is in core bundle, page 156. And paragraph. It says it's denied, but it does say that the claimants will set off against their reward the sum of 787,000. So I assume it's denied in the sense that they say that their claim will exceed ours.
And just to be clear, that suggests that Mr. Warwick doubtless in due course can tell us, but that suggests that were we to side with you on the appeal, the claimants would think in terms of the sum of money rather than the shares.
It may well do that. That is a matter for...
and if that were the outcome, and if that were claimant's position, it would be useful to know whether your clients would be content with £787,000 rather than the shares.
I will take instructions on that, my lord, and confirm that specifically. The next issue then is openings and what was said in opening submissions. The claimant's written opening is in the supplemental bundle, page 76.
I'm sorry, I missed that reference.
Sorry, it's in supplemental bundle, page 76.
Thank you.
At the bottom there we have a section that says outline submissions, and what my learned friend did was go through each of the issues for trial in turn. And the first one is issue 1. What does the word prospect mean? And we see that at page 77. Issue 2 is to do with a material adverse change in the turnover based on annualisation of the first 5 months from the May forecast, and whether or not that was less than the previous year. That has fallen away, but there's some discussion at 62 to 65 about what it was said had happened in August and September 2018, what Mr. Dearman had done in his expert report in modelling. It said at 64, there's an evidential question to answer as to whether the defendants were aware of the status of the key projects. And then we have something about what material means. So the defendant's awareness probably only goes to the accuracy of the records on my case, on the records policy. Anyway, issue 3 is the key one. That's over on 79. It's dealt with in the briefest terms. It says its position is explained above and by Mr. Dearman at 4.3.5. I'm not sure where precisely is being referred to as above, because there's a chronology of events. Then there's what we've seen in relation to issue 2. It might be that part. Mr. Dearman 4.3.5 is not in the bundle, but having been back and looked at it, and of course we know that the particulars of claim is inspired by Mr. Dearman, it says essentially the same thing as paragraph 12 of the particulars of claim. So this is not venturing into new territory, it's going back over what's in the pleading. My written opening, if I could invite the court to go to page 108 in the supplemental bundle. Paragraph 10. I invite the court please to read the opening paragraph of paragraph 10 and then paragraph 10.2. And then footnote 5 develops the point about the reference to the documents being extraneous. And so whatever is said in a document or a document being wrong, that has nothing to do with the accuracy of similar prospects. Rather, it concerns, as the final sentence in the footnote, differences in prospects as at the first completion date and since the account date. The oral openings transcripts are not in the bundle, so we will spare you those, but I broadly went over this in oral opening. My learned friend, that's right for me to say, that in response to my focus on the pleading in this particular point, my learned friend emphasised that the pipeline documents were one of the issues and the inaccuracy in them, and he referred to particulars of claim paras 11 and 37 to 38, which we've seen. And my point on that is we're not suggesting that wasn't in the pleading, we're just saying it doesn't go anywhere, and so if you strip out that as extraneous, or as my Lord Justice Newey put it, being in there to say it's no defence to point to these documents because you should see them on a modified basis to reflect the true position. So we weren't saying it's not in there, we just said it's extraneous and doesn't take anything any further forward. So pausing there again, we can still see no one's approaching this the way the judge approached it. Closings. In closing submissions, for the first time, there was something of a shift by the claimants in their case, but still not to what the judge did. And we can see that in the supplemental bundle, page 131. Issue 3. Another friend says at 18, this issue calls for a comparison between the company at 2 points in time, viz. The account date and the first completion date. So that was common ground as to the legal approach. 19, another friend says, as regards the account date, the prospects of the company can be shown in a number of ways, including, and then it refers out to an information memorandum and some pages of it, the documents at F1 252 to 254, which I believe were some forecast documents produced in January for the purposes of the sale. And then there's the EBITDA as at January 2018, which is the 114,449. Court may recall that we looked at that figure when we looked at the May forecast. If one looks on beyond January, one sees that the numbers are rather less good, which maybe one and then a friend sought to focus on that one. But at all events, that's all new. That's not consultancy services revenue.
Just briefly, in terms of those, the information memorandum we haven't got in the bundle.
It's not in the bundle.
I'm not sure what F1 252 to 254 were.
That isn't in the bundle.
They're not in the bundle.
We can supply those if that would assist, but those aren't in the bundle.
Yes, I see. Well, let's see how we go. As to the last one, the 114,000, that's from a May document, is it?
That's from the May forecast.
Yes.
The figure is 214 on the large documents. We can have a look.
Yeah.
In the bottom left, there's the 1.628 million figure.
Yes.
Some suggestion that that January EBITDA figure would be the prospects of the company.
I mean, of itself, this would not have been available in December 2017.
No.
Or indeed, probably January 2018.
No. I mean, there might be a question as to what you would predict based on what you had then, but that wasn't the basis on which the trial was conducted. We then have paragraph 20 of my letter friend's skeleton. As regards the first completion date, the prospects will be for the court to assess. With respect, it's not very helpful. But however, the overwhelming evidence is that the true position, as at 12th October 2018, was materially adverse. The forecast and pipeline documents did not reveal the true position; they concealed it. The true position emerged from the August and September management accounts. Evidence, and those Mr. Dearman does gets you to a similar place. Evidence as to the true position can be found as follows. One, from the Dearman report, the actual position for 2017 was 4757564. So that's back to consultancy services revenue. That is back to what the pleaded claim was. And for 2018, the position was 3572. And then they said for Mr. Thompson, his EBITDA for 2017 was 997019, and for 2018 was 1758897. That is not quite the right figure in relation to the EBITDA for 2017, because you have to make adjustments and so on, but that's in Mr. Thompson's report if we need to look at it. But again, the comparison being drawn is with 2017 and 2018, which we say is wrong-headed, but at least the point about the Dearman report does reflect the pleading and suggests that broadly that was still the key comparison the learning friend was asking the court to draw. Our written closing is at page 151.
Do you mean
No,
that?
it's not. This is wrong reference. I must mean 131.
No.
Might be 133 it starts.
Might be 133.
Yes.
My lord is correct. Thank you very much. And it's paragraph. Apologies, let me find this. Paragraph 62.3.
14.
14. Apologies for the error. If one goes up to the top of that page, one sees that the introduction to 62, which is the 6 breaches, has already been addressed in the opening submissions. The positions haven't changed there. And if you go up to the top of the next page on 140, we talk about knowledge. Say it's common ground to the extent that the claimants have actual knowledge of the facts and circumstances. They're not entitled to claim.
Sorry, where
I've
is
lost
that?
where
Sorry.
you are. I'm sorry.
I apologise. The top of page 140 and paragraph 57. So that's our written closings. We then finally go to oral closings. And then the friends closing issue 3, we can find, I hope, at page 169. On day 7, starting at page 22, 25, which says, so then we turn to issue 3, as at the first, we go up to the top of 23, completion date, since the account date, had there been a material adverse change in the, we leave turnover really, because we're talking about prospects, on the basis that this turnover or prospects wasn't properly reflected in the documents. Rather than me read it out, I suggest the court reads down to 923, please. So that is no real advance on the written submissions. It's referring to the same 3 documents there. For what it's worth, it doesn't really unpack it, tell you where you go Then, if I could invite the court please to read on, because my learned friend then turns to deal with the position as at the 12th of October, and that will take you through rest of 23, 24, and down into, in fact, down to 26, line 3, please.
So it's 2693.
Yes, 26, line 3. Then move on to issue 4. So that's addressing prospects at the first completion date based on the forecast and pipeline documents as per pleaded case, and saying that they're not revealing the true position, and focusing on performance in 2018, again as per the pleaded case, but we say just the wrong inquiry. There's a reference to a November pipeline document. That is in the bundle if it's helpful to look at it. We may as well, it's page 294 in the supplemental bundle. I'm afraid there isn't a big printout of this as far as I'm aware. If it would help, we can provide any documents in living print. But just to put what my learned friend has said in context, it may be helpful to see that. So in the bottom half of the orange marked opportunities, you have TfL, NIDEC, Kerry Group. You don't have BBC at this point. You've already seen my learned friend talking one through. That the global figure, notably in that pipeline, is 13.43 million unweighted. There was no attempt to compare that with a pipeline from anywhere near the account date, which may be particularly relevant where, of course, as I said before, NIDEC didn't exist at that point, nor did TfL. The only one that did at that point was Kerry, which was in a pretty similar position as at that time. My oral closing submissions are in the supplemental bundle. If we can take them for 173.
Sorry, yours are at...
173, Melanie.
I'm so sorry, thank you.
And it's page 125, line 12. 125, line 12, and I'd invite the court to read down to 126, line 11. 128 within the transcript, so in the bottom right of that page 173, lines 3 to 16, please. So we make clear in those passages that this attempted new case, if that it be was not pleaded, is entirely unclear, and had it been properly known in advance, would have been investigated further and addressed. Obviously, you'd want to be talking to witnesses about, does that properly represent the prospects? What are the documents should I be looking at, showing the court, so on and so forth. But that was never the focus of the trial, so therefore it wasn't in the witness evidence, it wasn't the focus of cross-examination on either side.
Now that's all in the context of what you say the claimant's claim was. You say the judge came up with something different.
Yes.
So at this stage of the argument, you're saying, well, what the judge came up with, that different thing, wasn't open to him because of what had been said earlier.
Yes, and it wasn't this, so relevant to point out that it's different from what had been said in the pleading to some extent, but still not what the judge said, my lord, quite right.
But when you're 1 to 8, when you're saying, well, the pleaded case or the case now advanced doesn't work, that's dealing with a slightly different point, isn't it? That's dealing with why the pleaded case doesn't work, whereas in your ground 1 or 2, whichever we're on, you're saying that's different from what the judge did.
My lord, that's right, yes.
And the judge does talk about EBITDA at 126, doesn't he? If you look at line 18.
Yes, so the question of whether prospect should be equated with EBITDA, I fully accept that that was ventilated and discussed, and that was something that the judge could consider. My complaint on that is that the judge got it wrong on the meaning of, on equating prospects with EBITDA.
Yes, I see.
On the narrow legal point.
Well, he asked you the question, doesn't he?
Yes, yes, my lord, he does.
And you say,
No.
You say no.
well, you say, you're wrong. Would you say it was wrong? And you say, yes, I would.
So that was discussed and ventilated, and it's a narrow, it's a small point of law.
That's it.
And he doesn't go on. I mean, I haven't looked at it all properly. He doesn't go on to say, well, I would be comparing EBITDA as you would say it at the same date.
Exactly.
He develops the point, actually. He comes back at you and says, you would, at 1279, so you would say prospects includes expected EBITDA, but does include others as well. And you say, actually, my lord, I'm not sure you use that tone. Actually, our definition, we don't say prospects include expected EBITDA.
My lord, yes. So our objection on that point as to what it means, I'm not taking that on it wasn't in the pleading, but the issue of what prospects meant was issue 1 for trial, so that was, in terms of the interpretation point, not suggesting that that wasn't in the frame. The question of what was pleaded to be the prospects at a given time, whether that was in terms of EBITDA, etc., that's a separate point. That's a factual point of particulars of the case point.
And you take it head on again at the bottom of 127, because the judge says, when you talk about the prospects of the company, it's to talk about future profits, and again you say no.
My lady, yes. My lords, my lady, I wanted to go next to page 174 and to look at page 130 of the transcript, lines 3 to 23.
And you'd like us to read those?
Yes, please. It's more along the lines of, as my lord says, it's the objection to any attempt to run a new case rather than the judge's case, but just for completeness in terms of what was said.
That's the notified point, though.
Milady, it is now. It isn't notified in relation to what the judge found, because, of course, we didn't know the approach the judge was going to take. But
It isn't notified in what may be the new form.
exactly. And, Milady, if I may, it shows that we would indeed, had the judge's approach been advanced to us and we've been given an opportunity to comment on it, of course we would have taken the same notification point before the judge then, but we were denied that opportunity. It is a basis for us objecting to any case other than what was pleaded, because the pleading reflected the notice. But if you go beyond the pleading, you're then talking about a claim of a different nature, and it's not been notified, and that's a fundamental problem. So, issue 2, part 3, was the judge's approach unjust? We've seen what was pleaded and argued. The question is, was this open to the judge without raising it with the parties, or without it being pleaded and adopted? And we say simply, no, it wasn't open to him to proceed in the way that he did. And there are 3 points really on that. First, it was common ground that as a matter of law, the prospects warranty required comparison of the position between the 2 relevant dates. That is the orthodox approach. No one contended for the judge's interpretation or anything like it. And what the judge did is not any sort of middle ground between this part of my case and that part of Mr. Warwick's case. It's something quite radically different. It's a fundamentally different inquiry. The judge did not raise his radically different his radically different alternative interpretation with the parties in the way the Supreme Court did in Hussain. And indeed, even not raising the legal point, we say, is unjust, although I appreciate that we can have a debate about it here, and in that sense, that can be fixed, but it's not really fixing it because it should have been done correctly at trial. So it's still unjust that the judge did it in the way that he did. The second point is the point on notice. We say that the judge's approach, had it been notified to us either by the claimants or by the judge, I don't blame the claimants for not raising it, it just wasn't their case, but had it been notified to us by somebody, we'd have taken the point about the notice provision in the SPA. Perhaps I can just leave that there and pick it up again in ground 3, because that's one limb of the ground 3. But that's a reason why it's unfair, we say, because that's an important legal point that we would have wanted to take. Third, the fact that the judge did not ventilate his proposed alternative interpretation meant the parties weren't able to make submissions to him on it based on the facts. The issues that the parties addressed included what the claimant's actual knowledge was of revenues for 2018 from the 4 projects based on their respective pleaded cases. But nowhere did they address what a reasonable person would have thought at a particular time based on EBITDA for 2018 on either of the judge's bases. And findings about what a reasonable person might have thought based on information passing between the parties, that is not a middle ground, that is a different inquiry. So this is not a case like Ali and Dink, we say. Had that been raised, we would have had to go through in detail what we say the document showed about what a reasonable person would have thought at different times and pitch the case that way. What does Malone Friend Skeleton say about what was open to the judge and why what the judge did was fair? That is at core bundle. I see already my references. It's wrong, I think it's the very end of the core bundle, paragraphs 29 and 30. Page 276. And the learned friend makes 3 points. The first is the pipeline documents identified in issue 3 and the outline issues document took centre stage at trial. They were in the core bundle and the witnesses were cross-examined upon them extensively. That's true enough, but it's not very meaningful, we say, because the question is centre stage for what purpose? They were used to some extent to explore the defendant's belief when preparing them, and also for addressing the issue of what actual knowledge the claimants had in relation to the 4 projects, but not used for addressing the reasonable person question for EBITDA for 2018, still less 2019, which the judge takes into account as well, based on the information passed back and forth between the parties, because that wasn't the issue. The second reason given is that the state of knowledge of the first claimant as to the company's prospects was made a key issue by the defendants. See outline issues 8 and 9. We can go and have a look at the outline issues, but they refer to actual knowledge. And should we have a look at it? It's page 89 of the core bundle. Issue 8, did C1 have actual knowledge at the date of the agreement of any of the alleged facts, matters and circumstances constituting breach of warranty, and if so, what was its knowledge? And given the nature of the allegations of breach, the alleged facts and matters and circumstances related to the revenues that the 4 projects would make in 2018, and the nature of the pipeline and forecast documents, but actual knowledge is the point. And the learner friend's framing there, if we go back to 276, paragraph 29, the learner friend has framed this as the state of knowledge as to the company's prospects. We've got to be very careful with how we use that phrase in the particular context of this appeal and what is meant by prospects. We were talking about the 4 projects. So if that's what my learner friend means, fine, we were talking about actual knowledge in relation to the 4 projects. We need to be careful how we use that word prospects. The third reason that my learner friend gives at the end of that paragraph is the judge arrived at a decision that took into account the submissions of the defendant's counsel, Mr. Lowe, for example, at various paragraphs of the judgment. And to which we say that it's the same answer. And you can do a control F to find my name in the judgment and points where the judge took into account my submissions, but what matters is what were my submissions on. They weren't on the judge's approach or actual knowledge. So we could look at those particular paragraphs if it would help, but 125 is the meaning of prospects. That doesn't help here. 129 is my submissions about the importance of the fundamentals of the company the claimants were acquiring, not the reasonable person analysis. 154 was my reference to what spreadsheets would demonstrate in terms of actual knowledge. There's actual knowledge. And 156 relates to the ground 4 point on TFL revenues, which we'll come to under ground 4, but it's nothing to the point here. So yes, the judge took into account certain of my submissions, but that doesn't take us anywhere. Para 30 we should pick up here in relation to the judge's findings as to breach. My learned friend says the appeal doesn't appear to involve challenging the judge's findings as to breaches of the prospect warranty. These findings involve the judge's assessment of the prospects, and you've got to be careful with that word, of the 4 contracts. For completeness, these findings can be summarised as follows, and then there's a summary. Those are paragraphs of the judgment, by and large, that we've been through, and the point is the judge is making a finding as to what the position was in 2018 based on the revised forecast. Do we challenge the finding in relation to what the revenue would be in 2018 and the position of those projects? Would revenues be realised in 2018? No. My learned friend is right in that respect. That's not part of our appeal. But my learned friend is not right to say we don't challenge the judge's findings as to breaches of the prospects warranty, because we say the judge's findings of breach go well beyond those issues, and they should fall away if the judge took the wrong approach or took an approach that was unfair. So, my lords, my lady, we say for all those reasons the judge's approach was unjust, involved a serious procedural irregularity, and it should be set aside on that basis as well. Obviously subject to my points about variation in relation to the counterclaim and consequentials. My Lord Justice Newey indicated earlier it might help to say something about remedy and setting aside, what I'm loosely calling setting aside, but I hope the court knows what I mean, in relation to the claim and possibly a chance of remitting the case back. There's been no suggestion of remitting in my learned friend Skeleton, but I'll address it now. It may be there's more to be said later, and of course it may be that the court in due course, depending on where it goes, would find it of assistance from, if that was a route that the court was thinking about going down later, we'd be happy to assist then. But in terms of where we are now, what do we say? We say that even without further submissions, the court could and should safely conclude that this is a case where the right order to make is simply to set aside the findings of breach against my clients and draw a line under the matter there, this having already been going on for 5 years now. The simple reason for that, first of all, is to look at the claimant pleaded case, which we have, and I don't propose to go through it again in detail now because I've made my points as we go. But we say it's essentially a strikeout point, even assuming that that case were established on the facts that the consultancy services revenues were what they were at those 2 dates, whether on the basis of the 4 projects or otherwise. That does not constitute a material adverse change in prospects once one properly interprets the prospects warranty. Which is a matter I've already addressed as part of ground 2. One part of the pleaded case is about the documents not properly reflecting the true position. We say that's extraneous. The other part is to do with the drop in turnover. We say turnover is not prospects. You're looking at the wrong time period. All points I've already made and don't need to labour and go over. So that's the claimant's pleaded case. We say it's bound to fail.
I mean, I quite follow the way you put it. Were it not bound to fail, as you say, then the position on your case would be that the judge had simply failed to deal with the way in which Mr. Warwick was putting it.
Yes.
So there would be no judicial determination on the case that actually, on your analysis, was being put forward by the claimant.
Yes.
Yes, I follow. So it really has to be a bound to fail type point.
It would still be open to the court to decide that the matter should be at an end now. It's somewhat similar to Almadetti and the judge saying, I've decided to do it on my own basis, and that's that. But obviously that would be a relevant factor in deciding what to do. Where it is, we say, clearly bound to fail, then it's a pretty clear case that there's no point sending it back for remission. The second point on this is, my learned friend might say, conceivably, I'd like to run a case that I didn't plead. He hasn't yet said that. I'm not sure whether that is a point I ought to preempt or not, but we would say that that would be quite extraordinary at this stage in circumstances where we're now well after trial. The learned friend's case, as things stand, is the pleaded case because he's never sought to amend it. We made our objection to that form of the case abundantly clear. So if it were to be remitted, we would say, obviously, if you wanted to run that, that would need permission to amend. And there's no point remitting for that purpose where no application has been outlined now, clearly outlining the case my learned friend says he might want to run, and where it's quite clear that any such application should fail because the only case any different from the pleaded case that was ever hinted at was in closing submissions based on, here's 3 documents that might tell you something about what prospects might have been at the accounts date, and it's a matter for the court to decide what it was on the 12th of October 2018, which is wholly unsatisfactory and wholly inadequate. And we say, my learned friend had his chance, he didn't take it, he took his case based on the pleaded case, and there should be no opportunity now for it to go back. Any amendment would clearly be refused, and this court can either say it would definitely be refused, or it can say, exercising our discretion, we would refuse it, and therefore the right approach is to just not remit. One point of authority on this that may assist is the Senate Electricals case, which is in the authorities bundle at page 23. This is not a case about what one should do in relation to remedy, but it's a case about the importance of pleading an alternative basis in terms of quantum, which is another reason why we say the case shouldn't go back, which I'll develop in a minute. If in this judgment, this is a case that, as many of them in the bundle do, involved a sale of a company under a share purchase agreement, if I could ask the court to go on to page 26, and paragraph 9 of the judgment. It says there that Senate, the claimant's primary case, was that damages should be assessed by applying a price-earnings ratio of 13.67, derived from the actual transaction to the difference between warranted profit and the actual profit, maintainable earnings. In the amended statement of claim, the sum was 26 to 27 million, based on a number of alleged breaches of warranty in relation to a management accounts, as you can see over on the left-hand column of paragraph 4. This was based on a number of alleged breaches of warranty, which together showed that the profit for 1990 was overstated by 3.34 million. Senate failed to establish a number of the alleged breaches, and at the conclusion of trial, the overstatement was 1.9 million, which, if you do it on that profit earnings basis, takes you to 17 million pounds. If we go on to paragraph 11, then we'll see what the judge did with that. The judge rejected the profit earnings approach. He did not accept the plaintiffs had suffered no loss. He said that if the accounts had disclosed the correct figure, the whole negotiation would have been conducted at somewhat lower level, and that the price would have been 5 million less, and that was the basis for damages claim. And as we can see, if we go on in the judgment, that basis of claim was technically pleaded, but it was disavowed and was never pursued and never argued. And so there was a procedural fairness point taken in relation to that. If we see at 12 then, STC appeal on 2 main grounds. They say the judge should have found there was no loss, and his approach to the assessment of damages was not open to him since it was not the way the case was conducted at trial. Alternatively, the 5 million figure was excessive. At para 50, para 50, which is page
35.
Thank you, my lord. 35. Paragraph 50 is at the top left. A pleading point. The plaintiff must plead the damage claimed and set out the method by which he arrives at the claim. An alternative approach should also be pleaded. If I could invite the court, please, to read paragraph 51 about the importance of that and why one has to do that. I ask the court to note in relation to that one reason why you should set out an alternative measure of damage is because that might affect what the other party does in relation to settlement. They might say, I want to settle that alternative claim because that one looks quite sensible. I don't think your jackpot damages claim is very good. I'm not going to settle that one. That's relevant, we say, simply as a matter of first principles in relation to notices as well when we come on to that point. If I could then please ask the court to look at paragraphs 53 and 54 on the right-hand side of the page. So if a claimant decides to go for jackpot damages, sometimes the court will be able to help them out and work out a lower amount. But if they've simply failed to put an alternative basis of claim, or we would say by extension of first principles, fail to articulate what their damages claim is in relation to each of a number of separate claims that are brought, which is what we say is what happened here, both in the notice and in the particulars of claim, then it doesn't really lie in their mouths to complain if the court says, I'm sorry, you haven't proved your claim because you didn't tell us what your loss should be in relation to that. And so we say in circumstances where the claimants never pleaded a case properly in relation to what the damages were for the prospects warranty, that is another reason why that should just be the end of the matter now. And in fact, this comes back to my Lord Justice Newey's question about what do we do if the judge simply got it wrong, but the pleaded case isn't bound to fail in terms of the breach. Might not be bound to fail in terms of the breach potentially, but it's still bound to fail in terms of the quantum, because the quantum of the prospects warranty claim was not specifically set out. And as I said earlier, sometimes quantum is a point that one finds in practical reality is dealt with later. And we still take the pleading point, but it's sometimes the case that you get an expert report that says, well, this is what my case will be on quantum. And in our case, we have sequential expert reports. So the claimant has an opportunity to put in Mr. Dearman's report, to which Mr. Thompson then responded. Mr. Dearman's report does not set out a separate calculation of the prospects warranty claim. So they had a second chance, subject to pleading points, but they had a chance to give us notice of what their claim would be on that before trial. They didn't take it. And the position they took at trial was, and we'll see it in the joint experts report when we get to ground 3, the experts would be happy to go away and come back and produce a report on what the prospects warranty is. And we said, that's not how it should work. You should draw a line under this. They've had their chance at 2, and they haven't taken it. Sometimes I appreciate you get that, and it's a matter for the judge to decide what to do if it's a matter of simply getting the experts to finesse certain findings that the judge has made. But where fundamentally they haven't even attempted the calculations, we say that is reason enough to say claim is bound to fail, but on a different point, or is sufficiently problematically pleaded that it would be right not to remit. Could I invite the court please to read 55, and then we'll move on from this case. 55, before the court does, is to do with the fact that this was not a live issue at trial and whether that was unfair. And the point that the court will see there is it's not just about whether the issues were in play and addressed, because actually some of them were addressed by counsel in that case, but they weren't addressed focusing on the issue in the way it would have been focused on had the point been a live one. And indeed, the judge might have been more focused on counsel's submissions on the point had it been a live one. So for those reasons, my lords, my lady, we say the right outcome is to set aside the judge's order insofar as it relates to the claim and to vary it in relation to the counterclaim and to reconsider the consequential rulings on costs and interest and so on according. But of course, if the court were, contrary to my submissions, to be minded to remit or want to consider it further, then obviously we would ask for an opportunity to assist the court with that if that would be of assistance to the court. Ground 3, then, this relates to the notice and the adequacy of the notice that the claimants put in. And there are 2 limbs to this, as I've already suggested. The first is about the quantum. Does the notice have to set out the quantum of the claim? And did this notice fall short of what the contract required by failing to do so? The second limb is the point that the judge's approach was not notified. So even if the judge's approach was A, right, and B, open to him as a matter of procedural fairness, does it fall away in any event because it's contrary to, there was no notice, so therefore there was, the condition precedent was not fulfilled. So it's contrary to the requirements of the notice provision. The first and second points together raise 4 issues, which I'll come to after some preliminaries. Those are: 1, what's the true interpretation of the notice clause? 2, did the claimants comply with it on the facts? 3, if not, was it not reasonably practicable for them to comply with it on the facts? Or did they comply because it was not reasonably practicable to set out the quantum of the claim? 4, is it open to us to run the point regarding notification of the case that emerged for the first time in judgment? We propose to start then with the interpretation of the SPA, then what the judge found, and then some case law before going to those 4 issues. The SPA is at core 9, page 163. This is the definition section. I'm taking the court through first, if I may. Page 163. The word claim with a capital C is defined, and it's defined as a claim for breach of any of the warranties in Schedule 4. Can we then please go on to clause 11 in the agreement? We'll find that at page 180. It's worth looking at clause 11.3 before we get to the key one, which is 11.4. 11.3 says the seller shall not be liable for a claim unless the seller's liability in respect of such claim, together with any connected claims, exceeds £10,000. To make it very clear that each claim is capable, in principle, of being quantified separately, and that you might need to look at that for the purposes of this provision. There's then in 11.3.2 a provision about aggregation. It's a second threshold condition or condition precedent, which is the amount of the seller's liability in respect of such claim, either individually or when aggregated with the liability for all other claims, exceeds £100,000. So the point being, when the contract wants to talk about aggregate liability for claims, it does so in terms. That clause then finishes with defining what a connected claim is. 11.4 then is the key clause for our purposes, and the question to the court will be, what does it mean? It says the seller shall not be liable for a claim unless notice in writing summarising the nature of the claim, insofar as it is known to the buyer, and as far as is reasonably practicable, the amount claimed has been given by or on behalf of the buyer to the sellers. 11.4.1, in the case of a claim for breach of the tax warranties, we can skip that. 11.4.2, in any other case, so that's our case, on or before the expiry of the period of 24 months commencing on the first completion date. So you have to give a notice within 2 years of the 12th of October 2018. We'll come back to what that means. Issue 3.2 is what the judgment says about what it means, and if we can start at paragraph 185 of the judgment. And that is at page 78. The judge cites clause 11.14 at paragraph 186. There's a summary of relevant case law at 189 to 191 that I would invite the court please to read. I propose once we've finished looking at the judgment, we'll then look at 3 cases, Highwater, Primus and Triumph and Tioco.
But you'd like us to look at 189 to 191?
Lord, yes, please. (192) then is the next place to go, and the judge records my argument. Mr. Lowe argues that the pleadings pleads 6 separate claims, 2 breaches of the turnover warranty, 1 breach of the prospects warranty, and 3 breaches of the records warranty. He therefore says that the fact that the notice given did not specify in respect of each of these breaches the quantum of damages sought in respect of that breach means that the notice should be regarded as non-compliant and therefore disregarded. He also argues correctly that if this were found to be the case, the claimants must fail completely. It's not entirely clear what the judge means there. It may be that he's in fact accepting my submission that you do have to, in principle, notify each claim. It may be that he's simply referring to the consequences of invalidity. I had taken it to be the latter, but it may be a point of interpretation that, in fact, the court was with me on that point, but simply against me on the reasonable practicability point, or reasonableness as the judge put it, because I don't see any clear finding by the judge that you don't, in principle, have to notify each of the claims. At 193, the judge then says, before I go into 193, I did want to ask the court please to read that passage in 192, quoting from Senate. The court picks up the point that I've already taken your lordship's relationship to on the Senate, but there's a second point in Senate about notices, which is indented. Key reasoning then is at 193, which I would please invite the court to read. So the judge is saying, in reality, it was not possible to quantify each breach because the assumptions of one breach assume another, which then has to be valued. And in essence, you can't separate out which breach caused which part of a global damages figure. And he says that the claimant's giving a single figure was the best they can do and must mean their estimate was reasonable. And note that he says reasonable and not reasonably practical.
At the same time, if it were indeed the best that they could do, that would suggest it hadn't been reasonably practical.
My lord, yes, but one has to look at that point in the context of the prior point that I just made, namely, he's saying that it is impossible to do it. And impossible is indeed the word that he uses in refusing permission to appeal. So if that is wrong in principle, then that, we would say, falls away as a finding that it's the best they can do, because it's premised on that. At 194, the judge says in line 3 that the notice left no doubt as to the allegations of breach made or the calculation mechanism to be applied. We say neither of those is an answer to the point about quantification, stating the amount. He also says that the defendants were not disadvantaged, but again, that's not the test, and it tends to suggest that the judge was looking at whether it was reasonable, not really focused on whether it was reasonably practicable. Finally, at 195 to 196, there's a citation of Tioco, which in turn cites RWE and Mrs. Justice Gloucester's statement as to what notices require, which the judge says he considered were met. I will invite the court to read that in a moment, but the fact that those criteria were met doesn't answer the point about separate notification. So it doesn't really take one very far forward, even if that were right. My lords, my lady, the next point I wanted to go to is looking at case law in relation to claims for breach of warranty and notification. And there are 3 cases. One of them is high water, that's at Authorities, page 92, a decision of His Honour Judge Waxman, QC, as he then was, which concerned the sale of a company called Major Stake to High Water by Ms. Graybill. At page 94, place to start within that, and in the middle of the page, extracted as the contract, and at sub 4 within that, we see the notice provision, not liable for a claim unless the vendor is not liable for a claim unless it receives from the purchaser a written notice of the claim stating in reasonable detail the matter giving rise to the claim and the nature and amount of the claim. Go on, please, to page 102. And His Honour Judge Waxman, QC, refers at 38 to findings of Mr. Justice Cook in Laminates in relation to what it means by the nature of the claim. He says the parties in that case agreed, unsurprisingly, this is halfway down 38, that the reference to nature meant notification of what is being claimed and the basis for it by reference to the SPA, namely the form and substance of the claim. We also agreed that the reference to the amount claimed required a calculation on the part of the purchaser of the loss which was allegedly suffered. Then, next, para 43. And the issue there was that there was a misrepresentation claim that was advanced in the particulars of claim that wasn't mentioned in the notice letter. At 43, the judge says, given the commercial purpose of such clauses is to enable the vendor to know in sufficient detail what he's up against, not least because it might then enable the parties to settle without recourse to litigation, I cannot see how a claim letter which confines itself to breaches of warranty without any reference to misrepresentation at all can comply with the notification clause here. And what I take from that is the importance with notice clauses as a matter of commercial purpose in making someone aware of quantum of each claim so that you can consider settlement, among other things, in relation to that claim. Some of the cases talk about making financial provision in relation to a claim. Of course, that doesn't apply here because my clients are individuals. So it's not about a global figure making financial provision. It's about knowing where you stand in relation to each claim and potentially considering settlement because some of the claims may be better than others. Para 45, I would invite the court to read, please. In that case, the claim had gone up in the particulars as against what had been in the notice. But it doesn't matter really in principle. What you need to know is what each claim is worth, and that emphasises that a vendor might take a different view when he knows he's facing a claim of particular proportions, and that it's no answer to say damages will be assessed in the round, because you need to know what you're facing when the notice comes in. The second case I want to look at is Triumph.
Can I just ask you, is there a distinction between what Judge Waxman says here about contrasting claims of misrepresentation on one hand and claims of breach of warranty on the other,
My Lord,
with what you say is the position here, which is what the complaint officer here, that there were different claims of breach of warranty?
My Lord, we say it doesn't matter, because the fundamental point is there are two different claims, and you need to know where you stand in relation to each of them. The point of principle, the reasoning that His Honour Judge Waxman QC gives here, applies equally, we would say, to two claims for breach of warranty, sounding in different amounts of damages. It's not enough to notify one breach of warranty claim and the quantum of that, and then say I don't have to notify the rest of them, just because it happens also to be a breach of warranty claim, we would say. Please could I ask the court to go to page 224 in the authorities bundle. That's the opening page of the Triumph case. There are a range of breaches of warranty in that case, which are summarised in paragraph 5 at page 227, which we don't need to get into the detail of, but that's where it is for the court's note. The point of interest, we would say, is that the warranty in that case was essentially in the same terms as here. So if the court goes on to 242, para 97, referring to clause 9.7, says it excludes liability for a claim unless within 18 months from completion, Triumph gave Primus notice in writing of the claim, summarising the nature of the claim as far as it was known to Primus and the amount claimed. I appreciate there's no reference to reasonable practicability, but in terms of essentially what is required prima facie subject to that, it's the same. And so then it's interesting to note what the court then says about that type of notice provision. At 98, it's about commercial certainty. 99 is the quotation from Senate that we saw in the judge's judgment here. Please could we go on to paragraph 115 of the judgment, which is at page 248. Paragraph 115, I would invite the court please to read. So it does not require, assuming that one interprets our clause in the same way, it does not require full particulars in the same way as you would have in a pleading. That's perhaps unsurprising. But the description and quantification should be such as to give formal, unambiguous notice as to the basis of the allegations, so that Primus could investigate, respond to, and make financial provision for the claims. And we say it goes beyond financial provision. In our particular case, what's particularly important is knowing about each claim, so you can think about settlement, and simply so that you know where you stand. Para 126 is the final one to look at. 126 makes clear that it's each claim that you have to notify. This goes to my Lord Justice Baker's point. It's not sufficient to notify one claim for a breach of warranty. It's got to be each one. All claims in respect to breaches of the warranties would be properly notified. That's what the parties intended, including the amount claimed. third and final case I wanted to look at is Tiyoko, if I'm pronouncing it right, which is page 89 of the bundle. That's the wrong reference. Page 197 should get us to where we need to be. Yes, that's right, 197. Apologies. This was a case about an alleged breach of tax warranties in a share purchase agreement, where it's alleged that the notice was insufficient. I want to look at it for 2 points. And the first one is paragraph 21, where it is said, as was recognised on both sides, every notification clause turns on its own individual wording. That is a proposition for which my learned friend has cited various cases, and it's not one from which we dissent. But insofar as my learned friend wants to suggest that you should ignore all the other cases and they don't give one any assistance, we read on the next sentence that says, reference to previous decisions can still, however, be of some assistance. My learned friend is quite right that there are cases out there where the courts have said, I didn't find it of any assistance in a particular case. In other cases, though, the court may do. So we offer it to your lordships and your ladyship in the hope that it is of some assistance in this case. We suggest it may be a particular assistance where the wording is particularly similar or indeed the same. The second point in this is at paragraphs 25 and 26 in relation to the case of Noberhar and the Hutt Group about construing notice clauses contra preferentum, which is a point that my learned friend takes. And it's really the bookends to the passage at 18 cited at 26 that we say really matter. It's what we want to draw attention to. And Lord Justice Briggs, as he then was, said, upon the basis that there remains a principle that an ambiguity in its meaning may have to be resolved by a preference for the narrower construction, if linguistic, contextual, and purposive analysis do not disclose an answer to the question with sufficient clarity, and then the bit that follows on from 26 is the court, having said that the contra preferentum rule does apply in principle, the court must still use all its tools of linguistic, contextual, purposive, and common sense analysis to discern what the clause really means. So we say what that really means is it's a factor, but it only really comes in if you can't get to the answer by the standard route of looking at text, context, purpose. And as we'll come on to, we say the position is perfectly clear applying those normal parameters here, and there's no real role in practice for contra preferentum to play here. We come then to sub-issue 1 of the 4, which is interpretation. Helpful to have the clause in front of us, perhaps, which is core 180. The sellers shall not be liable for a claim unless notice in writing summarising the nature of the claim, capital C, and as far as is reasonably practical, the amount claimed has been given by or on behalf of the buyer to the sellers within 2 years. My learned friend's position is that this clause does not require the notice to give separate amounts for each breach. We say the contrary, and we say that's clear from the language of this clause. Notice has to be given in respect of each claim, so that is the cause of action itself, each breach of the warranty that is said to give rise to a remedy. And I don't understand that point, that the claim itself has to be notified and each of them has to be notified to be in dispute, only what one does when one comes to quantum. We see quite clearly that the notice must summarise the nature of the claim. We've seen in the authorities what that means, formal unambiguous notice making clear the basis of the allegations made to allow the defendants to investigate it fully, not full particulars, but still something substantial, tells you what the substance of the claim is. You can't just say breach of warranty X, or that there has been a material adverse change at large. You would have to say, at the very least, there's been a breach of the prospects warranty because the position at the account date was X, but the position at the first completion date was Y because. Parking, if I may, the caveat of reasonably practicable for now, it's also necessary to notify the amount claimed. And the immediate issue is, does that mean each claim with a capital C, or can you give an omnibus figure in the way the claimants did here? And we say this: when the clause says the amount claimed, it must and can only mean the amount claimed pursuant to the claim being notified, because the duty to notify the amount arises as part of the duty to notify the claim itself. It is not and cannot be a duty to notify the amount of some other claim, or the amount claimed for that claim plus a bit extra, or some combination of claims. It is the claim being notified whose amount needs to be specified, so the recipient knows how much it is said that specific claim, which must be individually notified, is valued at. Let's take an example to illustrate this. Imagine that after 6 months, the claimant notified a breach of the records warranty. They allege that the May forecast was inaccurate. To say that EBITDA for 2018 would be 1.5 million. They say that if it had been accurate, the company would have made 1.5 million EBITDA in 2018 and beyond, and their claim would be worth whatever it was here, 8.5 million. But in the event, the company's only worth 1 million, hence the 8.5. Then 1 month later, they notify a second claim. The second claim a month later is for a breach of the prospects warranty. They say that, for example, consulting services revenue in 2017 was 4.8 million, and now it's 3.5 million, a drop of 1.3 million in revenue. Then instead of quantifying it, they say, we don't need to quantify loss because we previously quantified damages for a different claim that we've notified. That's somewhat facetious, but we say there is no difference in principle between sequential notices like that and putting them in the same document. We say that that second notice would obviously be invalid. The duty of notification is not altered by notifying more than one claim in a single document, which you call a notice. The clause does not concern quantification of notices or total value of claims. It concerns quantification of claims. If something is a separate claim, it needs a separate amount. The clause is entirely neutral as to how many bits of paper that you use. You can do it 1 month apart, as I've just said. You can put it all in one document. But how you go about it shouldn't affect what the content is of the document. So we say the language is clear, and indeed we can contrast this with the case that Manona Friend has cited, Hopkinson, at page 203 of the authorities bundle. Clause 6 in that notice, in that shared purchase agreement on limitation and liability was set out. That said, the purchaser shall not make any claims against the warrantors, nor shall the warrantors have any liability in respect of any matter or thing, unless notice in writing of the relevant matter or thing, specifying the details and circumstances giving rise to the claim or claims, and an estimate in good faith of the total amount of such claim or claims, is given to all the warrantors as soon as possible. So that form of clause is out there in the industry. It is used sometimes. And it's the simple point that you could have used different language if that's what you meant. Indeed, it's the same point I made by reference to 11.3 earlier. When the contract wants to refer to aggregate value, it says so. That's the language. We say our interpretation accords also with the commercial purpose. As discussed, the key purposes of notification are enabling you to know where you stand, generally, prepare and respond, and to consider settlement. To that end, knowing the value of each claim may be of very great assistance. It might be a low-value claim with good merits, and a jackpot damages claim with terrible merits, a try-on. Knowing the value of each one lets you know where you stand. We saw that very point being made in Senate in the context of pleading, but we say it applies also to notices. Same principle. Another purpose for knowing about the value of each claim is so you can assess 11.3. Appreciate that someone might say they're connected claims, but you want to be able to assess that as well. That's why you need to know the nature of the claim so you can assess if they're connected. But you need to know about the amount so that one of your objections could be actually, that doesn't get over the threshold, we say. Now, of course, I accept that that the claims may overlap. You might have 3 claims, especially if they're connected claims arising out of the same set of facts, where you obviously wouldn't just add up the numbers for those claims and say that's my damages, because that would be double recovery. You can assess the overlap. If you know the nature of the claims properly, it might be helpful for the claimants to identify a global claim size too if they want you to settle, but that's not what's required. The requirement is not the total as it is in Hopkinson, the requirement is the individual claims. That was a choice the parties made. Indeed, it may be that the judge agreed with that, depending on your interpretation of 192, but the point is a live one here, and it's for this court to determine either way.
I don't think it's matters actually for our purposes, but on your case, could you have a rolled up complaint of breach of paragraph 19, whatever it is, the one with turnover, financial position?
19.1.2.
19.1.2. I mean, could you have a notice that says there's a breach of the records warranty, so much attaches to that one. There's a breach of 19.1.2 in that turnover and prospects were wrong, and give a single figure for turnover and prospects?
We would say no, because we would say that each really is a separate cause of action, because you need to establish different facts to establish each of them. One is material adverse change in turnover, one is material adverse change in prospects. I can see the counter-argument where my lord is coming from, that one would say, well, it's a single warranty, either of those constitutes a breach. You might characterise those as different particulars of the same breach. Might have been what happened in the Rock case. We would say that's not the right approach. That there may be cases where you could say, actually, these are just particulars of the same breach, but we say that the differential between turnover and prospects is a big enough difference that in terms of the facts, they're different causes of action, the facts you need to establish your claim. But as my lord prefaced my lord's question, it doesn't matter here because this was a omnibus warranty, omnibus notification in respect of both records warranty and 19.1.2. So either way, the claimants don't get home. That is the next issue. What did the claimants actually notify here? Did they notify the quantum of each claim? I can take this shortly because I don't understand that there's any suggestion that the claimants did notify the quantum of the prospect warranty claim. They notified an omnibus figure. What the judge says at 193, as we saw, page 80 of the judgment, so page 80 of the bundle, final line, para 193, they notified only a single figure for the cumulative impact of the breaches. That's the judge's finding on what they did as a matter of fact. You can't really go behind that. It may be that in truth, this was a figure based on the records warranty, for reasons I've explained, as the 1.5 million times by the 6.43 that gets you to the 9.465 million minus the 792 for the actual value as they put it, which gets you to the 8.5. The prospect warranty, of course, would never sound in anything like that, sensibly, because that's based on the material adverse change of the 2017 position and the 2018 position. And we know that EBITDA for 2018 was about 850,000. And the reference for that, if needed, is Mr. Thompson's report, which is in the supplemental bundle, page 37, and the table at tab 10.10. There was an adjustment downwards that was made to that in the judgment, but it doesn't matter because it's clearly so far away from the 1.5 million that we can see this was not a notification of the prospect warranties quantum. So the question 3, and perhaps what it really all comes down to, was it not reasonably practicable for the claimants to give a value for the prospect warranty claim? And it's helpful on this to look at the judge's summary of reasoning in refusing permission to appeal, core 237. Last full paragraph on the page. If I could invite the court, please, to read that.
237.
Here, 237, my lord. Yes, it's a paragraph. Yep. Last full paragraph starts here again in the question. I'm grateful. over on the next page, we get the judge explaining his answer to that question. The issue was addressed in expert evidence. The defendant's expert sought to argue that it would have been perfectly possible. The claimant's expert said that it was impossible. I'm entirely with the claimant's expert. I cannot for the life of me see how individual claims could have been attached to figures, as I explained in paragraph 193, nor was it necessary for individual claims to be quantified in order for the defendants to know the extent of the claims, plural, against them. The notice was reasonable, and I cannot see any grounds for appeal. There are a number of references to the word reasonable in these. No reference to reasonably practicable. And it's not about whether what the claimants did was reasonable or it was the most they could reasonably do. It's about whether the notice is reasonable. That's why the judge is referring to the position of the defendants and what is necessary for them to know. It's nothing to the point what it's necessary for my client to know. It's what is to the point is what's reasonably practical for the claimants to have done. So we say this really does underline that that was the approach that the judge took.
Was this an extempore?
This document...
This bit?
Yes and no. It has
Well, it says it's called agreed note of judge's reasons for refusing permission.
as accepted and amended by the judge. That is what it says in the bookmarks on the left-hand side, and that's what it represents. So the judge gave. I don't know if my lord has. This is in the electronic bundle. It won't feature in the hard copy bundle, but in the electronic bundle, it says on the left-hand side, parties agreed note of judge's reasons for refusing permission to appeal at the hearing on 27th March 2023, as accepted and amended by the judge.
Agreed and approved note.
It's in the index at the front.
So
I'm grateful.
anyway,
So yes and no is the answer, because
so he doesn't get off the hook on the grounds that he could have been using reasonable to mean reasonably practical, you say.
No, my lord, no. He's made very clear what he was doing in the judgment was looking at reasonable.
But he says, I cannot for the life of me see how individual claims could have been attached. And if that's the case, then surely it wasn't reasonably practicable.
If it's impossible, then it's not reasonably practical.
So it goes back to 193 in the judgment.
Yes, which we've seen, and makes essentially the same point.
In reality, this exercise is in reality not possible.
Yes. So
Is that not synonymous with reasonably practical?
well, my lord? Yes. If it is actually impossible to do, if you cannot quantify the breach for the turnover warranty,
Reasonably
then it can't be reasonably practical. It's impossible. So it can't be reasonably practical. No one can do it. The first oddity. Well,
I mean, reasonably practical is a not possible. Full stop is a more absolute than reasonably practical, isn't it?
exactly. The greater includes the less, and we would accept that. If it's impossible, it can't be reasonably practicable. So was the judge right to say it was impossible? Now I was going to come on to that in a moment. I was going to look at a case on what reasonably practical means first, and why it's different, and why it matters. But I appreciate I will need to tackle was it impossible, and I will do that. The first point is to say, draw out that those two tests of reasonably practicable and reasonable are distinct things. And the case that we've cited for this is London Underground and Knoll, and that's in the authorities bundle. It's in tab 3 of mine, so that's page 43. The facts of that case were that an employee was dismissed on the 10th of April 1997. She then had 3 months to bring a claim for unfair dismissal by statute, unless it was not reasonably practicable to do so in that time. You can extend time, the court will be familiar with that. After being dismissed, she went through an internal appeals process, which took some time, but then, and in the course of that, she was given an offer for reinstatement, but then that was withdrawn, and after that she sued for unfair dismissal, but the 3 months had passed. So if you're looking at that from a reasonableness perspective, you could well understand why she hasn't brought the claim. If you're looking at it from a reasonably practicable perspective, there was no impediment to her bringing the claim, and that's a different story. And the question is whether the tribunal below had got it wrong. If we could go to page 48, please, in the judgment, just to focus in on the test and what it means. And it's the passage from E to G, from Palmer and Southend on Sea, Lord Justice made distillation of the authority. Could I invite the court, please, to read that? So it's not just reasonable, it's not just is it physically possible, it's somewhere between the two. Reasonably feasible might be another way of putting it. But there's certainly a focus on what is possible physically, practically, in reality to do. We've got 51 then, Peter Gibson, Lord Justice Peter Gibson's judgment at C to D, saying, I would accept that if the test had been one of reasonableness, as distinct from reasonable practicability, the employee would be entitled to succeed. Case seems a hard one. I have sympathy for the employee, but the time limits in general are strictly enforced, and the tribunal has not found a single fact that showed it was not feasible for the employee to complain to the tribunal by the 3-month deadline. Lord Justice Judge, also on that page, please, between F and G. It's not the same as other tests for disapplying just and reasonable, or if there's a good reason. It's one of practicability. Statutory test is not satisfied just because it was reasonable not to do so. But there are, as I said, also Lord Justice Waller at F to H, citing Lord Justice Brandon in the Walls Meat case, which it focuses on whether there is an impediment which reasonably prevents or interferes with you being able to do it, be it physical or mental. Probably not necessary to read that now, because I'm not suggesting that this court has to exactly equate the test with what's done in the employment tribunal context that's been worked up over the years. But I do make the point that it helpfully draws out that practicable adds something of substance and focuses is on what can reasonably be achieved and done if you try.
Does it cast any light on when an appellate court can interfere with the finding? I mean, if we read the bit saying it just wasn't possible as meaning it wasn't reasonably practicable, what test do we apply in deciding whether we can interfere with that finding, conclusion, whatever?
If the court's applied the right test, then that seems to be a finding of fact or evaluative judgment, which is toward the more hands-off end of the spectrum, as it were, if I can put it that way. If the court's applied the wrong test, then it's for you to decide the point afresh.
Even when, I mean, you say it's the wrong test because it talked about reasonable, but inevitably the same answer would have to follow if the judge has found, as he seemingly has, that it was just impossible.
Yes.
So you can't really say that the applying of the wrong test made any difference to anything.
On the impossible point.
On the impossible.
On the impossible point, I would accept that. But if we go beyond the impossible point and the judge has made other findings about, was it reasonable for the defendant, did they need to know this, that, or the other, that is where we say he's trespassed very much into the reasonable territory. I mean, we say he was applying the wrong test generally, but my lord is right. If as part of his assessment of that, he said he's made a finding that it was impossible, then it makes no difference, because clearly the answer on either test would be the same.
Yep.
So is it impossible? Now that, although that is a finding of fact of or evaluation of some sort, because it sets the hurdle so high, in reality, is it impossible? It may well be that in practice this court finds that it can interfere because that's simply wrong. But let's have a look at that, because clearly that's an important issue. Perhaps the first point to make in relation to that is that it is a baffling finding in the extreme, in circumstances where the judge has himself sought to quantify a breach of the prospects warranty in his judgment.
I didn't hear the word used to describe it. Sorry, it's
Baffling. It's a baffling decision by the judge to find that this is impossible in circumstances where...
Well, he said in reality, well, in the judgment, he agrees with Mr. Dear, but it's in reality not possible.
Yes, in reality it is not possible, which is then amplified somewhat.
That's baffling.
I find that baffling in circumstances where he has himself sought to quantify a breach of that very warranty. in isolation, because he found all the other ones weren't made out. So that's what he had to do if he wanted to make a finding on the evidence. And let's look at what this comes back to the Lord Justice Newey's point about what test does one apply. Obviously, when one is looking at has the judge got it right, if there's been a clear misunderstanding of the evidence that he's looking at to draw his conclusion, that is a situation in which this court can then say, right, we can go more hands-on, as it were, here on this point. I'm going to look at the legal test on factual points in a bit, but that's one of the criteria that can allow you to do it. And we say that is what appears to have happened here. So let's look at what the experts said. This is my second reason for saying it's clearly not impossible. Supplemental bundle, page 56. And paragraph I.2.1. Different breaches, this is the heading, different breaches result in different calculations of damages. The experts agree in principle that different findings by the court in relation to each of the alleged breaches might result in different assessments of damages. The experts would be happy to assist the court further if required in order to assist in the assessment of damages on an alternative basis. So what you have there is the experts positively putting their hand up to the court and saying, happy to help if you want us to look at a particular finding of breach. So against that background, we would say whatever the threshold is for saying that the judge was wrong, he must have got it wrong, because the experts are saying it can be done. It's possible. Now what happened in practical terms in relation to the evidence was that Mr. Dearman did his omnibus calculation, which must be by reference to the records warranty breach. Mr. Thompson, in his response, said, well, let's do an illustrative calculation of one of the other breaches to see whether that gets you anything like the same amount of damages. Funnily enough, it doesn't. And the one that he picked was the turnover warranty. And that's in his report. That bit we've put in the bundle, but I don't propose to go to it. But he sets out how you can look at that one separately. And in the joint report then, Mr. Dearman comments on that. And we see his comments starting at I.4.1 on page 56 here. And the starting point probably best to go to is I.4.4 on page 57. See what Mr. Dearman says there.
1 point.
Sorry, I.4.4.
Thank you.
Page 57. So what Mr. Dearman is saying is that he says it's not possible to split warranty 19 and 20, since he says the records reflected no material adverse change, so Mr. Thompson's calculation implicitly assumes a breach of the records warranty. Now, as to that, he was wrong, because the judge found that there was not a breach of the records warranty. But in any event, what is happening here, we can see very clearly, is that there is a it may not be that Mr. Dearman is conflating it, but the basis for his objection to going down this road is that he says, I can't take that composite figure and cleanly split it out into two subfigures because there may be some overlap. That's what he's saying. And that may well be right. There probably is overlap between aspects of these different calculations of loss, but it's nothing to the point. It doesn't matter if they overlap. The fact is, you can take any one of them and calculate it. When you add them together, you might get a number total than the aggregate figure that you ought to be awarded once you strip out double recovery and overlap. But you can do it. We then get his next objection at I.4.5. He says Mr. Thompson's calculations, which are based in part on Mr. Dearman's adjusted revised forecast, reflects a breach of the prospect warranty, prospect element, and therefore his calculation of the alternative as warranted value for the turnover warranty also reflects a breach of the prospect element. It's the same point, it's overlap. I.4.7, he says, Mr. Thompson's approach is inherently inconsistent because it assumes the buyer had perfect information on the prospects, but with no breach of the prospects warranty. Yet the figures Mr. Thompson uses themselves represent a breach of the prospects warranty. There's no inconsistency at all. You just assume that there's no other breach and look to value the specific breach that you're tasked with valuing. You just put it out of your head. I mean, logically, it must be possible. The claimant could have just brought one of their claims for breach. Would they really be saying to this court that if they'd only brought a claim for the prospects warranty breach, sorry, we can't quantify this? If that was the case, they couldn't get any damages. It's ridiculous. You clearly can quantify it. I completely understand what is being said, and we see it at I.4.8, the summation. Mr. Dearman does not consider it is possible to separate the warranties in the way Mr. Thompson suggests. Separation, disaggregation is the language he used. We'll see in cross-examination.
Do we have a transcript?
We do, and that's
We'll carry that in a minute.
I'm going to go there next.
Okay.
And it's page 164. Let's go there now. Because the point being made is I can't cleanly separate out that one figure. We say that it's not an answer. Missed the point. Clearly missed the point. Page 24 of the transcript, day 6, line 6. I say to Mr. Dearman, you accept in principle that a breach of one warranty might result in a different claim value as compared with the breach of another warranty. He says, I accept that is possible. Whether it's possible to disaggregate them is not something that I was originally instructed to look at. We'll come back to that, but let's take an example. Go on. The next place to look is at 165. But it's notable that Mr. Dearman was not even asked to try to do the exercise that is apparently said to be impossible, but at the same time he was volunteering to do if it would help the court. (165), page 25, line 9. I say, in order to work out the damages in relation to this claim, and this is the example I've taken, is the July invoices schedule, which showed it. We haven't looked at that, but it showed a discrepancy, alleged discrepancy of about £50,000 in relation to July's revenues. So quite clearly, if that resulted in any loss at all, it's going to be small beer. It's not going to be £9 million. In order to work out the damages in relation to this claim, we're looking at the difference in value between the actual scenario and in the value of an adjusted version of that scenario where you adjust this one variable to increase the July revenue. Yes? He says, yes, I guess so in principle. It's not something I was instructed to look at. The point is, he's accepting it can be done. He's accepting you can look at another one of the warranties and you can do it. He wants to have some thought as to precisely how. We ask again on 26. We ask him to confirm that it'll be far smaller than the £9 million claim. Line 6, he says, yes, in isolation. What I'm struggling with is disaggregating this information because it's all relevant information to the prospects of the business and so on. That's disaggregation. That's the overlap point. Not about whether you can calculate any particular loss. On please to 166. Page 32. Page 31. Starting at line 16, he says, as we say in the joint statements, if the court finds on different breaches, then we would be happy to work together to provide a solution to that calculation. It's not something that I considered in my report because I wasn't instructed to consider it. So I was looking at Mr. Thompson's calculation, obviously, when I received it in his report, then we discussed it. But I don't agree with the approach. I agree with the principle of trying to do it. I agree with the principle of trying to do it, but I don't agree with the approach because it conflates a number of breaches in my view. Now, it doesn't matter whether he was right or wrong about whether Mr. Thompson had taken the right approach. Point is, it can be done in principle. That was his evidence to the court. And again, we go down bottom of 32, line 21, I ask, but in principle, it can be done. You can just assume the only breach alleged is this one, and then you work out where that gets you.
Sorry, where are you reading from now?
Sorry, the bottom of page 32, line 21, my lord. Sorry, when I say 32, I mean the internal transcript.
Yes, no.
Apologies.
31. 21.
The bottom of 32.
Yes.
Yes. But in principle, it can be done, I ask. And you can just assume the only breach alleged is this one, and then you work out where that gets you. Answer, in principle. As I say, as I'm sitting here today, I'm not quite sure how that would work to ensure it's a sensible and robust, provides a sensible and robust conclusion and answer. I say it wouldn't be that difficult if you were not here but in your office and able to do it with all the usual trappings of time. Yes. He says, no, that's not what I'm saying. Essentially, I disagree with the way Mr. Thompson has done it. I haven't thought about how one might do it. I just explored already a few minutes ago in relation to the July schedule. I would need to think conceptually and then look at the answer. Does the answer make sense from a calculation perspective? But it's not necessary to have all the trappings. It's also the thinking time. So obviously it would take some time for him to do it. Of course it would. He'd have to think about how to do it, which he candidly told the court quite extraordinarily, frankly, that he had never done before he had come there, of how he would do these separate calculations. But his evidence is crystal clear that it can be done. There's an overlap problem, but we say that is a fundamental misunderstanding of the judge, by the judge, of the evidence.
Is that the end of the transcript, or is there more?
That's the end of what I wanted to...
So where does so going back to 193 in the judgment?
Yes.
Where does the judge get, or what does the... I'm thinking about my Lord's question about what we do on appeal.
Yes.
Where does the judge get...
Where does he go wrong?
Where does he, on what basis does he... Well, where does he go wrong? I think that's the question. But what is the material upon, the evidence upon which he's reached the conclusion at 193?
Meaning specifically, I agree with Mr. Dearman that
I
this
agree with
exercise
this.
is in reality
not possible since.
Yes.
Well, Mr. Dearman points out the assumptions required to establish one breach necessarily for other breaches which would fall to be valued in turn.
Yes.
In reality, etc.
And that, my lord, I expect, although he doesn't say, comes from, well, one, what we've seen in the transcripts where Mr. Dearman says that raises issues in relation to the other warranties, and I'm not sure about disaggregation. And it also probably comes from the joint report where Mr. Dearman raises these points about disaggregation. But the judge has simply fundamentally misunderstood it. Now, Mr. Dearman's evidence could obviously have been more helpful in the way that he addressed things in the joint report, or indeed if he'd ever had a go at quantifying these different breaches, and he didn't. And let's set the context. Mr. Dearman and the claimant were on a bit of a sticky wicket on this one, and they wanted to have their cake and eat it because they had not pleaded or quantified a prospects warranty breach. And I am taking a point against them. Senate Electrical says you're in trouble because you haven't pleaded or quantified that breach, and the court can say, if you fail on your jackpot damages record warranty claim, sorry, go home. So, of course, what they want to then say is, oh, don't worry about that. If that's what you find on breach, we'll go away, we'll come back, we'll get you some expert reports dealing with whichever breach it may be, obviously includes prospects warranty. Be right as rain. We can sort that out for you, don't worry. But then when I come to say to him, well, surely then you can do all of these separate breaches, it's not that much of a problem, they're aware there's a reasonable practicability issue there, and that's where it favours the claimant, and perhaps Mr. Dearman, the court doesn't have to decide that, but it favours them to say, well, actually, it's a little bit tricky, we've got this disaggregation issue, but frankly, it's smoke and mirrors, and it misses the point.
I mean, it is implicit in what you're saying that if the claimants had won on everything in terms of actual breaches, and the omnibus figure had been the correct quantification of those claims put together, you would still have won.
I would still have won.
Yes, because none of the claims would have been notified.
My lord, that is my primary case. But my lord, the way that I put it below, the reason it's my primary case is based on the judge's finding about what was notified. The way that I put it below was that I understood that in practice, what had been done was to notify the records warranty breach. That does seem to have been what was done. And so the claimants notified that, but then they didn't bother doing the rest. And so they had their jackpot claim. They didn't have the rest. Now, what the judge has said is, you didn't do any of them, you just gave a jackpot figure. And on the basis of that factual finding, yes, we would say that was the case. Now, it might have been that someone might have wanted to run the case saying, no, that did include the records warranty breach as to the forecast, my jackpot claim, because look, the numbers are the same. Or that's good enough if the number happens to be the same. But yes, that is the logic of my claim, but there's nothing wrong with it. Nothing wrong with it.
So the claimant was all the way down the line, is given notice of a global claim, but loses.
Yes, because that isn't what they were required to do contractually.
No proper notification.
No proper notification. Condition precedent not met. They should have read. I mean, this is difficult, we say, as a matter of the clear language of the clause. You have to give the amount claimed for each claim.
I mean, I put a point that sort of makes one wonder about your case. Going in the other direction, if there had been separate identification in respect of the prospect's warranty claim, I wonder whether some of these other, as you would say, confusions would have arisen. There would have been a focusing on what was really at issue.
Well, my lord, that we would say is a point in our favour.
Yes,
because it explains precisely why it's critical that you give a clear notice stating what the nature of your case is and the amount claimed, because then you would know.
And of course, come the particulars of claim, there isn't that requirement which you say existed in the notification. So again, you get a global figure. If at any stage there had been a splitting out to try to work out what damages attached to the prospect's warranty, I wonder whether the nature of the claim would have been clarified.
It may well have been.
But if a different notification had occurred in relation to the prospect's claim alone and other claims as freestanding figures, and then that would have been pleaded because you would have pleaded the notices, and then you'd have those figures, although at the end it would be a global sum that was claimed.
Yes, and there's a cap in this case, and so it would have been subject to the cap and so on, and there would have been potentially a slightly thorny issue about what it all adds up to. But that's normal. That's what happens in these sorts of cases. But it's not the short point is it's not a total value warranty. It's an individual value warranty, and sometimes the outcomes in those instances are tough when you get it wrong. We can't shy away from that, and often the point is taken in these cases. That's a technical point, but as was said, I believe it's in Senate, but I don't have the reference at my fingertips. These aren't technical points, really, because you have contracted for a duty to tell someone certain things before you make a claim for good commercial reasons, so they know where they stand, and you've then failed to do that. My lord, I mentioned a missing page earlier, and I wonder if I might hand that up, because this goes to the reasonably practicable point.
I'm glad you had copies, Mr. Lowe, because I printed them out because they were emailed to me and then I left them in my room. So.
Thank you. I'm glad to hear that it's helpful, my lady. We did send it on the CE file, but I appreciate that sometimes it helps to make sure that you definitely got it.
Thank you very much.
Is this for ground 3 or ground 4?
This to ground 3 as well. Oh, sorry, yeah, this one is, sorry, this is my confusion. This is ground 4, sorry. There is another transcript reference I want to go to. Apologies. That will be ground 4. The final reference in the transcript is in fact in the bundle. My apologies. And it's page 163 of the supplemental bundle. And this is cross-examination with Mr. Dearman. It's not on the disaggregation, etc. point. It's on the fact that he did a full expert report before the claim was notified and pleaded. So if we look on page 163 and the internal page 5 of that, at line 10, we ask him, I don't want to ask about the content of your advice, but I just want to check what Mr. Warwick says is correct, namely that advice was taken from you before the notice of the 4th of September 2022 was drafted to ascertain if the claimant's claim for breach of warranty were well founded. He says, my lord, I was instructed at my previous firm, Mazars, in broad terms, the statement is correct. Just to provide context, I prepared a draft report. That draft is substantially the report that you see in the bundles today. And in fact, there's a schedule to my closing submissions that shows the similarities between Mr. Dearman's report, and it's a point I alluded to this morning with my Lady Justice Asplin. So what comes out, I will make good why I've referred to that in a moment. What comes out of all of this, we say, is this. The claimants engaged Mr. Dearman before they gave their notice in order to assess and quantify their claims. He told us, point 2, that he was never instructed to assess the value for each claim separately. Point 3, when asked about doing so, he was often hung up on the idea of disaggregation, which we say rather missed the point. It was obfuscatory and unhelpful, or charitably, he simply misunderstood. 4, nevertheless, Mr. Dearman accepted repeatedly that in principle it could be done to assess each claim in isolation. 5th, he said he didn't know how to do it there and then because he had never been instructed to think about it and he had not thought about it. 6th, he had issues with Mr. Thompson's approach, but as we've seen, that was really to do with the disaggregation point. And 7th, there was no suggestion by Mr. Dearman or the claimants at any point that Mr. Dearman lacked materials or information required to do the exercise. They acquired the company, so they obviously had necessary financial information and documents, and Mr. Dearman went over financial information in order to do it. He could have used the same information to quantify the claims individually. That just wasn't the instructions he was given and he didn't think about it. So drawing those threads together, that means we say the claimants have not come close to demonstrating that it was not reasonably practicable to value and notify each of the claims in this case, in a context where they had instructed an expert before their notice to help put together their case. They thought it sensible to instruct an expert before claim, obviously able to do that, because they did, and for what it's worth, it seems they thought it was reasonable to do that. So if an expert is needed for this task...
I'm just conscious, Mr. Lowe, that we've got about 10 to 15 minutes left, and I do want you to finish your submissions today.
My Lord, I'm grateful for that. Let me draw the threads together on this and then run through ground 4, which is mercifully short. So he was, Mr. Dearman was ready, willing and able to help with whatever was required for months before notice was served. No issue with lack of documents. He's accepted it could be done in principle. He couldn't tell the court that it was not reasonably practicable to do it, really, because he hadn't thought about how you would do it. How could his evidence possibly be that it's not reasonably practicable to do it if he's not thought about how you would do it? There's no evidence at all from the claimants on whom the burden lies on this, assuming that we get over the threshold that the judge was wrong, to show that it would not have been reasonably practicable. An exacting standard and the burden hasn't been discharged. Still less to show that it was impossible to do the task that Mr. Tierman was volunteering to do, and the judge himself did in his judgment. And as I've already said, if the claimants had confined themselves only to making a prospects warranty claim, they would have quantified it, no question. So we say the absence of evidence that it's not reasonably practicable should be determinative against the claimants. The obvious conclusion to draw in the absence of evidence is that it could be done, because that's what Mr. Tierman said to the court when he was asked. So we say separate notification of amount was required, wasn't done. The judge was wrong insofar as he concluded that it wasn't necessary, and he was wrong to conclude it was impossible, whatever the test may be, when there's a clear misunderstanding of the evidence. And the claimants haven't shown it was not reasonably practical. My lords, on the second limb, take this very briefly, we say it's outrageous for my learned friend to object to me taking a point about not taking a point on notification of a basis of claim that only appeared in the judgment. And if the court wants case law on it, there's Authorities Bundle, page 211, Court of Appeal decision in Notting Hill Finance and Review Shake from 2019, paragraph 21 and 26 to 28 refer to the test that applies about taking a new point on appeal. Fundamentally, paragraph 21, the appellate court has a discretion. The factors are at 26 to 28, but we say it's essentially a short point of law. It's easy to apply to the facts. There's no suggestion of any prejudice on the learned friend's part. And fundamentally, this is a claim of a different nature to the one that was pleaded based on a drop in consulting services revenue between 2017 and 2018. The nature and basis of this claim, the substance of it, was in no sense outlined in a notice, so it should fail for that reason. My lord, if I may move on to ground 4 in that case, the TFL point. My learned friend says this is a challenge to a finding of fact, so faces a high hurdle. That obviously potentially arises on the last point as well. So if we can go to Authorities Bundle 422, and this is an extract from Zuckerman in Civil Procedure. Which will help us on both points. And I would ask the court to look at the extract from Lord Reed in the Supreme Court at the bottom of the page, saying it follows that in the absence of some other identifiable error, such as, non-exhaustively, material error of law, making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or demonstrable failure to consider relevant evidence, an appellate court will interfere with the findings of fact made by a trial judge to satisfy that his decision cannot reasonably be explained or justified. Then at 25.205, we see there's a spectrum, and that depends on whether or not you are in as good a position as the judge. This is the issue of primary fact turning on credibility, multifactorial decision based on inference and analysis. We say, actually, we've looked at the relevant material. In this case, you are in as good a position as the judge was. There's not really much question of credibility. It doesn't depend on that. You can read the evidence. You can see whichever one of these tests one wants to apply. No basis in the evidence for the critical finding of fact, demonstrable misunderstanding, failure to consider the evidence. The judge doesn't consider the point that the expert said, yes, we can do it. So we say, actually, we're in territory where you can dive in much more readily than you would basis on a pure finding of fact after hearing a witness and deciding who was telling the truth and who wasn't.
When you say that, are you going back to ground 3?
I go back to ground 3 on the factual points there.
Yep.
On ground 4, it's essentially the same point, though, that you are going to be looking at the same evidence. And based on that, you'll be in the same position. It's not about credibility. And there's been a clear misunderstanding of the evidence, we say. This is dealt with in the judgment at 207 to 209. Page 84 of the core bundle. Invite the court please to read paragraph 208 and 209. So this is a point about whether you should include £32,700 for TFL in the August and September numbers. Mr. Dearman's methodology, page 42 of the supplemental bundle, 5.3.3, he explains what he did, but in essence what he did was he took the May forecast and then he took the revenues in relation to TFL and so on, and then he stripped those out, apart from the ones he added in for October to December on the 50% basis for TFL. He took out all the revenues for TFL for June, July, August, September. And then we see at 5.3.3b, he made an adjustment for October, November, December, but only for October, November, December, to take account of the fact that if you weren't working on the 4 projects, you might have been doing work on something else. So he increases what might otherwise be predicted as the EBITDA for those months. So given that the point is to reflect the true position of the 4 projects, and the adjustment only relates to October, November, December, if as a matter of fact there was work done in relation to TFL in August and September, we say quite clearly as a matter of his methodology, that ought to be included. My Lord, we've seen that there are 6 things that we can look at that deal with this on the evidence. The pleadings, which we've already looked at, where we pleaded, and the reference again is Core 124, Parallel 21.1 of the defence, work for August and September was done and later invoiced in the sum of 32,700. That invoicing is admitted in principle in the reply, but said in fact to have been in the amount of 36,350. So no suggestion in the pleadings that this work wasn't done, because you wouldn't invoice for it if it wasn't. We can look at the invoice itself, page 296 of the supplemental bundle. It's on decisioning headed paper. The figure in the bottom right there is 32,700. That's the work done 12.50 in August and then the rest in September. That's an invoice on after the claimants have taken over that was sent out. There'd be no suggestion that that was a fraudulent invoice for work that was not done at the time. No one's ever suggested that. Over the page 297, there's a spreadsheet from 19th of February 2019 setting out income from TFL. That actually accords with the figure in the learner friend's reply, the 36,350 for TFL. Again, clear that that had been accrued for work that had been done. So those are the first 3 points. There's then Mr. Bell's cross-examination, page 158. Page 158 in the top left we have page 25. I can invite you to look at line 9 please. We're talking about TFL and we've said they had done work for which they were intending to bill but they couldn't yet raise the invoices because they didn't have the PO, purchase order, is that right? Mr. Bell says yes, but the work was done, so they could technically accrue for the work. The project had commenced and boots were on the ground. I then look at the invoice with him as we go down the page. If you look at page 26, line 14, we say what it does show is that some work was done in August and that wrapped up in September. Yes. He says yes, and the day was billed in August. I agree. Then we say, and it wrapped up in September. Line 21, he says yes. There's some quibble over whether that means ramping up, but that's not the relevant point here. Over on 27, we ask him if you were trying to rewrite the forecast or prepare a fresh forecast on an up-to-date basis on the 12th of October 2018, you should include this in the work done as shown in this invoice. He said if they knew they were going to bill for it, yes, they should have accrued for it. You would have possibly accrued for it. But of course, he's already said the work was done. They could technically accrue for the work. The next is the cross-examination of Mr. Dearman. This is the missing page. Page 17, line 12.
Which I put it in my bottle now.
I'm sorry, I can hand up another copy. It's,
No.
Oh, 168A.
168A,
Will be the page in the
that's right.
supplemental bundle.
Thank you.
And we take him to the invoice, and at line 22 on page 17, I say, do you accept that this should be included in your revised forecast, given this work had been done at the first completion date? He says, if it had been completed, I would expect it to be accrued, already be in the accounting records. I may have this wrong. There's evidence it was never sent, never recovered. That's wrong, because Mr. Bell said that it was, and we've seen the invoice itself. And it's in the pleading, it's in the reply that it was later invoiced for that amount. It's simply wrong. And then he talks about his adjustment. That's his next gambit. And I take it out. Line 19 on page 18, I say in relation to the final 2.5 months, i.e. your adjustment is in relation to the final 2.5 months, right? And he says the final 3 months. The predictive part, answer the predictive part. Not the retrospective part, yes, the predictive part. October, November and December. In terms of the retrospective part, if this work for TfL has been done, you would accept that it should be included. If it has been done and it has been, and it's not reflected in the forecast for August and September, yes, I would. So that's Mr. Dearman's evidence. He would include it if the work had been done. There's then the second defendant's email of the 10th of October 2018 to Mr. Bell at page 277. This is the sixth one. Side of the judgment, the last point we need to go to. Mr. Bell asks in his email partway down the page, I saw that in the July and August accounts you've been awaiting the PO at TfL. What's the amount that could have been accrued for work done to date? Mr. Almariesh responds, hi Nick, positively we now have just got the mechanism for invoicing TfL sorted, so we're billing through SAP, and I need to find out the exact figures. Invoices will be going out shortly covering all the work we have done since July. Project started end of August, revenue ramps up in September. So work has been done, we will be billing for it, subject to mechanism. Turns out it was billed later, seemingly by a different mechanism, but that's not the point. The point is the work was done and was always going to be billed. The revenue quite clearly accrues. All the facts point one way. So where does that leave us taking stock? Oh, sorry, one last point, which I've already alluded to, is para 139 of the judgment, where the judge refers to the mandate for the 28750 that he accepts was in existence in July, Act 24th of July 2018. So he's identified the right to bill for work. It's not the exact same sum, but he's identified the right to bill for work. So it corresponds with that as well. So where does it leave us? The judge's conclusions at 208 and 209, 484. His first reason is to refer to Mr. Dearman's adjustment. But what we saw, and then the judge says, as we saw, that's for catching revenues arising after the effective date. He then says that the invoice dates from the 1st of February 2018 in unexplained circumstances and does not appear to have been foreseen or accrued as of October 2018. Well, frankly, there is no basis for that in the evidence. We've just been through all of the evidence. It's all one way. Never put to any of my witnesses that this was an invoice for work that wasn't done based on what it said on its face. No doubt because it was an agreed issue in the pleadings that this work had been done and invoiced. So it's not clear what needs explained, but there's absolutely nothing in the evidence to undermine that point. The judge appears either to have failed to consider the evidence or completely misunderstood it. Insofar as he relies on Mr. Dearman's adjustment, he seems clearly to have misunderstood it, or again simply just got it wrong, because Mr. Dearman said in terms the adjustment is for the prospective period alone. So how could it possibly have anything to do with what you put in for August and September? So the judge saying that the 2000...
Now, we really are up against it. I know one member of the court has a meeting.
I apologise, my lord. I have half a page left in my notes. Let me just check if there's anything I actually...
Okay.
My lord,
I think half a page will survive.
I apologise, and I'm grateful for your indulgence in the time taken. The judge says that 32,700 belongs with the NIDEC adjustment. Well, NIDEC is different because NIDEC was in the October, November, December period. TFL wasn't. So he's again demonstrably misunderstood. 209. The items identified are exactly the sort of thing for which this adjustment was incorporated into Mr. Dearman's forecast. I mean, it's simply wrong. There is no basis for that in the evidence. However you pitch the test, the judge cannot reasonably and justifiably come to that conclusion. My lords, this court has seen the evidence. This isn't a point that turns on credibility. I'm taking at face value what those witnesses have said. You're in as good a position as the judge. You can be hands-on rather than hands-off on that spectrum, and you should interfere with it. And for those reasons, if this point arises, because it's very much in the alternative, but we say 32,700 or the 36,350, either way should be added on to the actual value scenario.
And then it gets multiplied up.
And then that's why it's significant, milady, for two reasons. One, it gets multiplied up by 6.43, so that then comes close to 200,000. Also, the claimants beat a Part 36 offer in this case by £10,000. So the 75,000 bonus payment, etc., even on just this point alone, it's worth $250,000 plus. Unless I can assist further, and again, acknowledging my gratitude for your time.
Thank you very much. Mr. Warwick, over to you in the morning. 10:30.
My lord, yes.
All right.